This is a review for transportation law, beginning with a general discussion. So, the definition for contracts of transportation can be found in the case of Chrysostoma versus Court of Appeals. A contract of transportation is one whereby a person or association of persons obligate themselves to transport persons, things, or news from one place to another for a fixed price. What is the relationship of transportation law to public utility law? So first you look at the PSA, section 13B specifically. So this gives the legislative interpretation of what a public utility is, and this has been upheld in jurisprudence in several cases by the court. So during the deliberations of the 1986 Constitutional Commission, when there was a question raised of what is a public utility, the Constitutional Commission answered that this would include transportation, telecommunication, ice plants, and etc. So the nature of the franchise granted to those engaged in contracts of transportation. So the CPC is relevant here. Several things about the CPC. First, it can be sold as it has considerable material value. It is a valuable asset. That's the case of Raimundo versus Luneta. The CPC, under the case of Cogeo Cubao versus the Court of Appeals, the CPC is affected with public interest and therefore it is considered to have been submitted to the control of the government. Also, under the case of Cogeo Cubao versus Court of Appeals, the CPC itself does not confer upon the holder any proprietary right over the route which is covered by the CPC. So therefore, it is still conditioned on public interest. But again, the holding the CPC, this means you can transfer it or dispose of it for valuable consideration because it is a valuable asset or a property, but it does not confer any proprietary right over the route. The case of Raimundo versus Luneta Motor, certificates of public convenience have come to have considerable material value. They are considered valuable assets. So CPCs are included in the term property when used in a broad sense, and they are a species of property, and therefore they may be liable for execution. So the case of Raimundo versus Luneta Motor also talks about an important doctrine in transportation law, which is the prior operator rule. So the fact that the original operator did not succeed in his business, for which reason his certificates were attached, so execution was done against them, and they were finally sold at public auction, this does not necessarily mean that his failure was due to ruinous competition, because he could have also just been a poor manager of his own business. So Cogeo Cubao, I don't know, versus CA, a CPC is included in the term property in the broad sense of the term. Under the Public Service Act, a CPC can be sold by the holder thereof because it has a considerable material value and is considered a valuable asset. Although there is no doubt that it is private property, the CPC is still affected with public interest. Therefore, even though you hold the CPC and you can dispose of it or sell it as a valuable asset that you own, it's your property, for any considerable material value or for a valuable consideration, this transfer or this right to dispose of it is still submitted to the control of the government. Why? Because the CPC is still affected with public interest. So insofar as the interest of the state is concerned, a CPC does not confer upon the holder any proprietary right or interest or franchise in the route covered thereby and in public highways. So if you purchase a CPC from someone, that does not automatically make you the holder of such franchise or authority to operate. You still have to submit to any regulations that the state would impose for you to be authorized to actually conduct business on that CPC. Otherwise, you're going to be moving against public interest. So CPCs can be asserted against individuals or they can be asserted against the state. If the CPC is to be asserted against the state, of course, it will be subject to the regulations that are put in place in order to protect the interests of the public. But if it is to be asserted against private persons, such as in a contract of sale, then the CPC is treated as private property. So what is the scope of the franchise then for a contract of for transportation or contract of transportation? So There is a distinction between a ferry service and a coastwise or inter-island service. That's the case of San Pablo versus Pantranco. So remember, if you're talking about transportation by water, you have to check whether or not the route is inter-island or a ferry service. So ferry services under San Pablo versus Pantranco is conducted by either barges, rafts, motor, or stream vehicles between the banks of a river or stream. The ferry services are considered continuations of the highway when crossing rivers or lakes, which are small bodies of water separating the land. So, ferry service is a continuation of the highway. However, if the transportation over water is considered an inter-island or coastwise service, this would involve a steamboat or motorboat service between different islands, involving more or less great distance and over more or less turbulent or dangerous waters of the open sea. So, what is the significance of this difference? Essentially, if you have a franchise to cross highways, if you have a ferry service, it can be embraced by that franchise without need of an additional CPC. However, if it is considered a coastwise or inter-island service, that would need an entirely different CPC because that is outside the scope of the original franchise issued for operation on highways. Then there's the prior operator rule. The prior operator rule is where a first licensee or operator has a prior license, and this would more or less vest that first licensee or operator with a preferential right over another person who would seek to acquire another or a later license over the same route. However, there are three requirements for the prior operator rule to take place. So, for the prior operator licensee to have a more or less vested preferential right, first, the first operator should be keeping and performing along, they should be obliging with the terms and conditions of their license. So, the first operator rule cannot be in breach of their obligation of the under the license. The first operator must also comply with the reasonable rules and regulations of the commission. And lastly, the first operator must reasonably meet the demands of the public. So for the first licensee or operator to say that you have a vested and preferential right, so you shouldn't give another authority to another person over the same route. So the first operator has to prove three things. First, they are keeping up with the terms and conditions of their license. Second, they are complying with the rules and regulations of the commission. Lastly, they are actually meeting the reasonable demands of the public. So there's no need for an additional one because they're keeping up with what the public needs. So it's they're good with the license, they're good with the commission, and they're good with the public. So that is the prior operator rule. The rationale for giving such preferential right was discussed by the court in the case of BTC versus Orlanes. So the rationale for the prior operator rule is that if we were not to grant such a preferential right to the first licensee or operator, then the first licensee or operator would be deprived of protection over their investment, and they would be subject to ruinous competition, and thus it would defeat the very purpose for which the PSC was created. There are exceptions to the prior operator rule. However, these exceptions are when first, public interest and convenience would be better served by the new operator. Second, the old operator failed to make an offer to meet the increase in traffic. Third, where the CPC granted to the new operator is a maiden franchise. And fourth, when the application of the rule would be conducive to monopoly. And remember, under Section 11 of Article 12, there can be no franchise that is granted that is exclusive in character. So, again, the exceptions, if the new operator would actually better serve public interest or convenience, if the old operator failed to make an offer to meet increased traffic, so there's greater demand now, and the old operator failed to make an offer to meet it. Third, the CPC granted to the new operator is a maiden franchise. And fourth, if the application of the rule would favor a monopoly. So, Batangas Transportation versus Orlanes also says that so long as the first licensee keeps and performs with the terms and conditions of its license and complies with the reasonable rules and regulations of the commission and meets the reasonable demands of the public. So again, those are the three things that need to be complied with for the application of the first licensee or for the prior operator rule to apply, Batangas Transportation versus Orlanes says that those three things happen, then there's a more or less vested and preferential right over a person who seeks to acquire another and a later franchise over the same route. Otherwise, again, the licensee would not have any protection on his investment, and it would be subject to ruinous competition, and thus it would be defeating the very purpose and intent for which the Public Service Commission was created. That's Batangas Transportation versus Orlanes, or BTC versus Orlanes, on the prior operator rule. Okay? So, next, you have the case of the Kabit system. Also, just remember that the prior operator rule is not applicable when the CPC was already issued and this is being sold now to another person, okay? Okay, Kabit system. So this is a system where the grantee of a CPC allows another person to operate under such franchise for a fee. This is TEHA versus IAC for that definition. So another legal basis is Section 20G of the PSA, which disallows transfer franchise without PSC approval. Remember, you still CPCs are private property, but they are imbued with public interest and thus subject to regulation by the state. So the Kabit system is not penalized as a crime under our laws, but it is against public policy since it allows owners to transfer erring vehicles to another in order to escape liability. So it's an abuse of the CPC, which is a special privilege granted by the government, and it is personal in nature. So it is a cause for graft and corruption in government transportation offices, and it's contrary to public policy because it may allow the owner of a franchise to escape liability. So it is considered void and inexistent. So if for the case of prior operator rule, you're going to cite BTC versus CA, under Kabit system, you would cite the case of TEHA versus IAC, TEJA versus IAC. So what is the effect of the Kabit system? Again, even though it's not a criminal offense, it is contrary to public policy, and therefore, any contract which is found to be actually a Kabit system is void and inexistent. That's NCC 1409. Also under 1412, remember that there's a fundamental principle that our courts follow, and that is, in pari delicto, the courts will not aid either party to enforce an illegal contract. Instead, the parties are left where they are. The court also cannot grant any affirmative relief to parties in cases where they set up a Kabit system. Why? Because they are in pari delicto, and the court will simply leave them where they found them. So the operator of record is the original holder of the CPC, right? Or the holder of the CPC. They're considered the operator of the vehicle in contemplation of the law as regards to the public and third persons, even if the vehicle was involved in an accident and after it had been sold to another. So unless such sale has been approved by the state, which was then the PSC, then the sale is not binding upon the state or third persons. And for all the purposes needed, if anything happens with the vehicle that was registered under the Kabit system, the holder of the CPC is considered the owner of that vehicle. So TEHA versus IAC again, the Kabit system is when a person who has been granted a CPC allows another person who owns motor vehicles to operate under such franchise for a fee. Okay? Yes. The case of Lim versus CA. Also remember, for Kabit system, if you want to cite the legal basis as well, you can say Section 20G of the PSA rather than just saying it's contrary to public policy. Okay? So, and Section 20G explicitly disallows the transfer of the franchise without approval of the PSC. So that is the public policy which the Kabit system is contrary to. Lim versus CA. The thrust of the law in enjoining the Kabit system is not so much as to penalize the parties, but to identify the person upon whom responsibility may be fixed in case of an accident with the end view of protecting the riding public. The policy therefore loses its force if the public at large is not deceived, much less involved. So this is when the Kabit system would not apply in the case of Lim versus CA because the riding public was not actually involved. It was a collision between a passenger Jeep and then a truck. Okay? Because the registered owner of the Jeep, so it wasn't the passenger Jeep wasn't under the Kabit system. The registered owner of the Jeep was different from the driver of the Jeep. So, Kabit system, remember, it involves a public right. So there's also the private nature, rights, and obligations of parties inter se arising from transactions related to transportation. So if you're talking about private vehicles, which are not public utilities, why? Because of the absence of compensation or holding out their services to the public, then passengers are considered as accommodation passengers. Private vehicles transporting passengers who are accommodation passengers then are obliged only to exercise ordinary diligence to avoid injuring the passengers, okay? Private vehicles are not held to the extraordinary diligence standards that common carriers are held to. What governs private vehicles or private transportation contracts would be not the provisions on common carriers, but the provisions on obligations and contracts. Article 1761 of the New Civil Code also requires passengers to observe due diligence to avoid injury to himself or herself. Remember, the obligation of passengers to also not be stupid. What happens if there is no transportation contract? The case of Lara versus Valencia is instructive here. So, the owner and the driver of a vehicle owe to accommodation passengers or invited guests merely the duty to exercise reasonable care so that they're going to be safely transported to their destination, okay? So Lara versus Valencia states that the rule that has been established is that the owner or operator of an automobile owes the duty to an invited guest to exercise reasonable care and not unreasonably expose the accommodation passenger to danger or injury by increasing the hazard of travel, okay? So that's Lara versus Valencia. So even absent a transportation contract, a private vehicle still owes ordinary diligence, okay? Why was Valencia not bound by the provisions of common carriers here? Because there was an absence of compensation. So the passengers were considered, this is where he fell off the back of the truck. The passenger was considered a guest, okay? The liability of the registered owner in case of private vehicles. So for any sale, lease, or financial lease that is not registered with the LTO shall not bind third persons who are aggrieved in tortuous incidents, for the latter need only rely on the public registration of motor vehicles as conclusive evidence of ownership. So just go back to torts and damages for the registered owner rule. Okay? Remember, if there are four parties, the registered owner, the person who bought the vehicle, the employee of the person who bought the vehicle, and the injured party, then under the registered owner rule, by fiction of law, the registered owner is considered to be the actual employer of the driver, okay? This is for the purpose of the third party moving against the registered owner to claim damages. The remedy of the registered owner then is to recover from the actual owner or the actual owner of the vehicle, the person who bought it, okay? If there are only three parties where the registered owner is also the employer of the driver, then the registered owner has the available defense of having exercised the good diligence of the father of the family because 2180 would then apply. Remember, 2180 was effectively modified in a way by the Motor Vehicle Registration Act, and that's where you get the registered owner rule. Okay. So PCI leasing versus UCPB general insurance reiterates the liability of the registered owner in that they are primarily and directly responsible for the consequences of its operation, including the negligence of the driver with respect to the public and all third persons. So, regulations of the transportation industry then. There are 5 general regulations of the transportation industry. These are for the area of service, for rate fixing, for penalties, for permits, for equipment. So ARPPE. Area of service, rate fixing, penalties, permits, equipments. ARPPE. So the bodies that have the government bodies that are primarily tasked with the regulation of the transportation industry is, of course, you have your Department of Transportation. So it's the primary policy, planning, programming, coordinating, and implementing an administrative agency of the executive branch for the promotion, development, and regulation of dependable and coordinated networks of transportation systems, as well as in the fast, safe, efficient, and reliable transportation services. Okay? DOTR, obviously. It's transportation is in its name. But you also have things such as the Civil Aeronautics Board and the LTFRB, who regulate the business or economic aspects of a franchise. They give the franchise, they can grant franchises. So Mirasol versus DPWH, Mirasol versus DPWH speaks more on the functions of what is now the DOTR to formulate and recommend national policies and to regulate, when necessary, activities related to transportation. Okay? What other agencies do you have to remember? So if it's air, remember the Civil Aviation Authority of the Philippines, or CAP, CAP. So it works with the International Civil Aviation Organizations, and so it's responsible for implementing policies on civil aviation. So Civil Aviation Authority for air. There's also for air, you also have the Civil Aeronautics Board. So they are mandated to regulate, promote, and develop the economic aspects of air transportation. The case of PAL versus CAB. So the Civil Aeronautics Board was empowered by Republic Act 776 to issue temporary operating permits, and nothing contained either in said section or in Republic Act number 776 would negate the power to issue said permit before the completion of the applicant's evidence and that of the oppositor to the main position. So Kuwait Airlines versus PAL, again, talks about the powers of the CAB, and it says that the CAB has ample power to compel PAL to terminate whatever commercial agreements the carrier may have. So CAB, again, has the general supervision and regulation of and jurisdiction and control over air carriers, as well as their property rights, equipment, facilities, and franchise, okay? If it's land, so if air, you have CAAP and CAB. Land, you have the LTO, which is for the registration of drivers and motor vehicles. Then you have the LTFRB, which exercises quasi-judicial and regulatory functions with respect to land transportation. And it also has the important power to issue, amend, revise CPCs, prescribe routes, and reasonable fare rates. So that's LTFRB. And LTO for land. Lastly, you have water. So you have Marina, or the Marine Industry Authority, which has jurisdiction over the development, promotion, and regulation of all enterprises engaged in the business of vessels, shipyards, dry docks, marineways, shipping, and freight forwarding agencies and similar enterprises. What was the rationale of Congress for the deregulation of the shipping industry? It is to encourage investment by existing operators and to attract new investments. Okay? So just to remember the agencies: land franchises, LTFRB; traffic rules, LTO; promulgating rules for air safety, CAP; licensing airmen, CAP; CPCs, CAB; registration of land vehicles, LTO; registration of aircrafts, CAP; registration of vessels, Marina; CPCs for domestic shipping is also Marina; and rate setting for airports is CAP. So some important things here. So you have the Chicago Convention, which laid the foundation for the standards and procedures for peaceful global navigation. So it is binding because the Philippines is a signatory. And the Marina is also bound by the STCW, and this applies only to seagoing ships and not ships in internal waters. Okay, so that's it for transportation law as a general overview, the concepts, and the general discussion, as well as the powers of the state to regulate transportation contracts, including private transportation contracts.